Hello everybody. So in this video we are going to discuss article 13 of Indian Constitution, that is second article in part 3 of Indian Constitution, and it is second article in fundamental rights series as well. So we already have discussed article 12 before this, and we will be discussing other article of fundamental right as well. So at very outset, let me declare that in this video we will be discussing two very important doctrine, that is doctrine of severability or doctrine of separability, and number 2 is doctrine of eclipse, right. So this video will be little lengthy because of these two doctrines that is very important as far as Indian polity is concerned. So you need to bear with me. Speaking about article 13, as you can see on the screen, it does have 4 clauses. So the first clause, if you can see on the screen, it says that pre-constitutional or all pre-constitutional laws inconsistent with fundamental right will be ultra vires. So who will declare any such pre-constitutional law ultra vires? So Supreme Court and High Court does have power to declare any pre-constitutional law that is in contravention with fundamental right, that will be declared ultra vires or void, right. Now the second provision. So second provision reads that it prevents legislature from enacting any law which is inconsistent with the fundamental right. So if I have to conclude these two clauses, right, you will see that any inconsistencies, fundamental right has been given primacy, and any inconsistency, whether it is in pre-constitutional law, that is in cases with article 13(1) or post-constitutional law that deals with article 32. So any such inconsistency in any such law, right, that will be declared void by Supreme Court and High Court. Let us go reach out to 13(3). So 13(3) defines law, that what is law. You need not to be worried because we are going to discuss this in detail, right. So article 13(3) defines law. What is law? Article 13(4), it says that nothing in this article shall apply to amendment of this constitution made under article 368, and this provision was added by 24th amendment by Madam Gandhi, right. So we will discuss this in detail as well while discussing what is law. So let us enter into next slide and let us see these things in detail. So if you could read, it deals with inconsistencies of the pre-constitutional laws with the fundamental right and declares them void, right. So the question that you should be raising is, suppose there is a law, and if you know the structure of a law, you would be aware that a law has multiple provision. It may have 10 provision, it may have 20 provision, and suppose for an example say that one particular provision of a particular law which has 20 provisions. So one particular provision is violative of fundamental right, whether whole of the law will be scrapped, and it is here that this doctrine of severability or separability that answers that question, and it reads, instead of striking down whole statute, this doctrine opines that only provisions that is violative of fundamental right should be scrapped and not whole of the law, right. And try to understand, say judiciary is an unelected body, it is an organization of unelected people, so its tendency is always to protect the law because laws has been designed or passed by those popularly elected people, right. So it will strike down only those portions which are violative of fundamental right and not whole of the law, right. So let us take an example. So this is a pre-constitutional law about UPSC recruitment. So among other condition, among other eligibility criteria which suggests the age requirement, the educational requirement, it also suggests that the person of British origin will be given given priority during the final process of recruitment. Now remember that you are in 1950, right, your constitution has been passed, right, and article 16 prohibits state from making any kind of discrimination on the basis of religion, race, caste, sex and place of birth, right. So this provision of this whole law, right, is violative of article 14. So this doctrine, what it opines is that not whole of the law, because the other provisions are correct, right, those provisions are not violating any fundamental right, it is only this provision that is violating the fundamental right, that is article 16 in this case. This should be scrapped and not the whole of the law. So I hope that you do have understanding of this doctrine of severability, right. One more aspect of doctrine of severability, let us discuss this. So it might be that this provision which is violative of article 16 may be mixed up with this provision which was valid, and this provision is mixed up with this, and this is mixed up with this. So, these provisions, various provisions are jumbled up in that this way that these cannot be separated. So, in that case, this doctrine allows judiciary to scrap whole of the law, right. In cases where provisions are jumbled up, that the separation is not possible, in that case judiciary can scrap whole of the law. So, I hope आपको पूरा complete idea हो गया होगा, right. The only caution that judiciary has to take while applying this doctrine of severability is that while separating the law, the portions of the law, right, court should not kill the very spirit of the law or should not come up with a new legislation itself, right. So, 13.1 is over. Now, let us discuss article 13.2. So, it reads that it prohibits legislature to enact any such law which is inconsistent with the fundamental right, and even despite this instruction, if legislature comes up with any such law which is inconsistent with the fundamental right, the Supreme Court and High Court reserve the right to declare that law void, right. So, it is in this context that doctrine of eclipse comes into the picture. So, if you have read geography, you would be knowing this process of eclipse, right. So, this is sun, this is moon, and this is earth, right. So, in this example, for this example of polity, let us consider it this sun legislature as of now, this moon is nothing but fundamental right, and this earth is nothing but we, right, we living in the earth, right. So, we are the beneficiaries of this fundamental right, and this fundamental right, this cool fundamental right is protecting us from this legislative heat, right. So, now let us take an example for our better understanding after this example, right. So, this person, it dragged state of MP in a case in Supreme Court, right, and what happened actually, state of MP had designed a law which had monopolized or tried to monopolize the transportation sector, right. Now, the transporters of that area or that state, right, they collectively approached Supreme Court and they cited violation of article 19(1)(g), that was right to occupation, right. So, because of this law, Motor Vehicle Amendment Act, right, state was empowered to monopolize transportation sector, and that act had tried to take this right, that is right to occupation of these transporters away, right. So, there was a clash between right to occupation and this act, right. Finally, Supreme Court held that okay, right to occupation of these people, that fundamental right should take precedence over the new act, this amended act, right, and this amended act was declared void, right. But this voiding does not mean that this law was thrown completely into dustbin. This law was only sent into something called sleeping mode, right, and there may be situation when this article, if this article, the protection that is available under this article, right, if this protection gets away, right, that law will come into the picture, right, and that actually happened. So, what happened after some time, right, 19(1)(g), that is right to occupation itself was amended by the parliament, right, and allowed state to monopolize certain sectors like railways and all, right, and thereafter as soon this 19(1)(g) was amended and it allowed state to monopolize certain sector, right, that means the protection that was available, to these people, right, under 19(1)(g), that went away, means this moon has went away, and now these people, the beneficiaries of this right, will have to protect this legislative heat, right. So, this doctrine of eclipse says that if there is any law which is violative of fundamental right, that will get into the sleeping mode, but if that very fundamental right is amended, then that law will come into the picture. That is what this doctrine of eclipse is, right. So, I hope you do have clarity on these two doctrines, that is doctrine of severability and doctrine of eclipse. Now, let us move to the next thing and let us discuss this article 13(3) that defines law, right. So, the traditional understanding has been that laws are generally passed by parliament or state assembly, but that is not right understanding, right. Let us discuss this 13(3) and then we will have perhaps right perspective about what is law, and that will be used in this fundamental rights section, right. So, you may be seeing some institution or some rather customs practices, right, which has some amount of force, right. So, if there is a practice ongoing of human sacrifice and if it is widely accepted by a particular society in a particular state, that practice will also be called law. If there is one institution, say example of CAP, right, which has capacity to get its orders implemented or followed by mass of the people, so those orders will also come in the category of law, right. So, let us read it. All legislation passed by parliament, assemblies, ordinances by president governor, any bylaws, subordinate or delegated law passed by executive, even orders passed by collectors or DM in the district having force of enforcement should be considered law, right. Now, let us read this question. What if any CAP order violate your fundamental right? Can you take refuge under Article 32? The answer is yes, because this CAP order has the force of law, right, and if that their orders are violating any of your fundamental right, you can very much take the refuge under this Article 32 and you can directly approach Supreme Court and High Court, right. So, even customs we already have discussed, right. So, even customs and practices which has wide acceptance, right, such as orders from informal community meetings, those orders will also come under consideration of law, right. So, now I hope you do have broad understanding about what is law and what is not the law. And let us discuss Article 13(4), right, which deals with whether amendment made under Article 368 will be considered law under the meaning of Article 13 or not, right. So, you do have two Supreme Court cases and thereafter take of executive in 1971 on this question, right. So, Shankari Prasad case in 1951, although this case is very important and it deals with many aspects like whether fundamental right can be amended or not, among fundamental right and DPSP which should be kept on higher pedestal, right. So, it has delivered judgment on many aspects, but as of now, with respect to this article, we will be dealing only to respond this question. So, we will focus only on this aspect, right. So, in Shankari Prasad case in 1951, you will see that it said that law in Article 13 only means ordinary law, that the normal legislation that is passed by parliament or state assembly, and any amendment made under Article 368 will not be considered law, right. That means the fundamental right can be amended by using this 368, right, and that will be not called law, right. So, law in Article 13 means only ordinary law and not the constitutional amendment under Article 368. Then comes Golaknath case in 1967 and it says that constitutional amendment made under Article 368 will be considered law within the meaning of Article 13, right. Then finally, executive takes on this judgment in 1971, Madam Gandhi, and she comes up with two amendments, that is 24th and 25th amendment, although 25th is not relevant, so I have not mentioned it. So, in 24th amendment, she amends two articles, that is Article 368 and Article 13, right, and she finally says that constitutional amendment done through 368 would not be considered law under Article 13. So, that is the evolution of word law under Article 368, right. Let us move to the next slide, and here is one question, right, that you need to attempt on Article 13, right. So, with this we are wrapping up Article 13 as well. Bye bye. Thank you.